Before we begin, imagine standing in court accused of resisting police officers, refusing fingerprint compliance, and then challenging the very system processing your case. Sounds dramatic already, right? Well, that's only the beginning. In today's courtroom breakdown, one defendant questions the process, requests the judge's oath of office, and claims she was assaulted by police during a previous fingerprinting attempt. But that's not all. Later, another defendant returns to court hoping to avoid jail after telling a judge a story that doesn't quite line up with the documents. As the hearings unfold, we'll see how judges separate facts from excuses, why credibility matters more than most people realize, and how one small inconsistency can completely change the outcome of a case. Stay until the end, because one defendant walks into court expecting leniency and leaves facing jail time after the judge uncovers a critical problem with his explanation.
You waive your right to a lawyer?
Yes.
So I'll go ahead and arraign you. I'll set bond. You ask for my oath of office. You can approach John, give him my oath of office. You also have a motion here that I will address after I arraign you. It is alleged that you did commit the offense of resist, hinder, and obstruct an officer on April 29 to 26, at or near 23125 King Road in Brownstown at 12:01 p.m. That is count one. Count two alleges the same count. Resist and obstruct an officer or misdemeanors punishable by up to 500 fines, 90 days jail, costs, or all those. Do you understand that?
Yeah.
I can't hear you.
Yes.
Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty at any time, you'll be giving up all of those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes.
You still wish to waive your right to a lawyer? I will enter a not guilty plea. You acknowledge receipt of that oath of office?
Yes.
Okay.
Thank you.
You argue that you don't have to go for fingerprints, right?
What do
You filed a motion here. Emergency objection to fingerprint compliance deadline and request for stay pending adjudication.
Yeah. Well, I was trying to figure out, you wanted fingerprints for this charge? I filed a motion because I was literally assaulted by the Brownstown Police Department when I went there to get fingerprinted the last time.
On another case.
This is already becoming an unusual hearing. Most defendants focus on defending themselves against the charge. But here the discussion immediately shifts toward fingerprint compliance and alleged prior interactions with law enforcement. From a legal standpoint, fingerprinting is often a routine procedural requirement, not an admission of guilt. The judge appears focused on moving the case forward while keeping the process intact. What do you think? If someone genuinely believes they were mistreated during a previous encounter, should that affect future court-ordered compliance requirements?
Right in front of judge.
The initial charge is what I was there for fingerprinting for, yes.
All right. I didn't order you to get fingerprints on this kill shot, but I am going to order you to go get them fingerprinted now. I'm going to order I'm going to give you a $1,000 personal bond. You cannot leave the state without the consent of the court or violate any law or ordinance.
I feel for my safety.
Yeah. Let me finish. You're not to have any contact with the victims. If they happen to be the one fingerprinting you, that's one thing. Otherwise, you're not to write them, phone them, see them, text them, email them, or have any contact with them whatsoever. You're not to possess firearms. You're not to possess dangerous weapons. You're not to have any contact with prosecution witnesses. I'm going to order that you go over to Brownstown by 1 p.m. today to get fingerprinted and photographed. That's a condition of your bond.
The victims.
Would you please stop? Let me finish. You're not to have any contact with the victims.
The victims are the Brownstown Police Department.
That's their allegation. I don't know what happened, ma'am. I don't read police reports unless and until there's a conviction, but I am ordering you to go over there and get fingerprinted and photographed by 1 p.m. today. In the meantime, I'm going to send you to the prosecutor. You can discuss the case with the prosecutor, and we'll go from there.
Okay, so if I'm not supposed to, like, what am I supposed to do when I go there? Who am I supposed to actually talk to?
You're supposed to, you're gonna take the order, we're gonna fax over the order, and you're gonna take your bond sheet, and you're simply going to cooperate and tell them that you are there to be fingerprinted and photographed. If the individuals with whom you had the issue are, how do I say this? If they're the ones fingerprinting, that's not gonna be deemed a violation of the no contact order, okay? You understand what I said?
Notice how carefully the judge is drawing boundaries here. Even though the defendant claims the police department itself is effectively the victim in the case, the court is still enforcing a no-contact order while creating a practical exception for fingerprinting. That's a balancing act. Judges frequently have to perform protecting the integrity of the case while making sure required legal procedures can still happen. It's a reminder that courtroom orders are rarely as simple as they sound at first glance.
In the meantime, you can go talk to the attorney, the Brownstown Township attorney, see if you can resolve this. If you can't, we can set it for trial, okay?
So you said talk to the prosecutor?
Have a seat in the hallway.
Yeah, hang on. Yeah, you're gonna go talk to the prosecutor. You said you want to represent yourself.
Yes.
So you'll go negotiate with the prosecutor. You can explain your position to her. Maybe you can get her to dismiss it. I don't know. And if not, we can set it for trial.
Okay,
Okay?
thank you.
All right. See you back in here after you've talked to her. Jacob Michael Douglas.
All right. So, I'm supposed to be on camera. All right. So that was part one. She comes back. So I guess she's claiming that she was assaulted while trying to give her fingerprints, and she was charged with resisting or obstructing, something like that. Yeah. I don't know if she's a sovereign citizen, but it's a weird move to ask for an oath of office if you're not a sovereign citizen. But she doesn't really go too much more into the script. But I just wanted to put this out there so during her next appearance, she may go more soft-sit, hopefully, and then I can point you guys back to the birth video.
Shannon Sherelle Phillips, 261-50905A. What happened on this one? And B. Okay, your name, ma'am?
Sure.
All right, so we're gonna adjourn this for discovery, right? All right. What do you have for me, Heather? We're gonna maybe set it out a couple weeks.
That'll be July 1st at 8:45.
So July 1st at 8:45 will be your new date. Now, if you change your mind and decide you want a lawyer, you can fill out a petition for one, okay?
Thank you.
All right? I'm not your enemy here, okay? You understand? I'm sorry?
I said me either.
I don't know what that means. What do you mean?
I'm not trying.
Okay, well, good. Good. We'll get along just fine then. We'll see you July 1. If you're going to go, wait a minute, you're going to go down the hall. They're going to give you your paper notice. They're going to give you the copy of the bond sheet, and then they're going to send over to the Brownstown. So you should go over there right now and get printed, okay? Good luck.
And now we transition to an entirely different type of legal problem, one where credibility becomes everything. According to the judge, this defendant previously explained that he was driving because his father had just been released from the hospital. The court even delayed sentencing to give him a chance to provide supporting documentation. That's actually a significant opportunity. Judges don't always pause proceedings so defendants can strengthen their claims. The question now is whether the evidence will support the original story or create even bigger problems.
Mr. Wilson's here for the charge of driving while license suspended or revoked. Mr. Wilson entered a plea of no contest to this charge. Mr. Wilson, I went back and watched the video this morning just to refresh my memory, and it looks like your license was suspended because of multiple DUIs. You testify that you don't even own a vehicle. The only reason you were driving that day is because your father got out of the hospital that same day, and I accepted your plea. The state's offer, the state recommended disposition at that point was 30 days in jail, but I wanted to see if you could get some documentation that your father really had gotten out of the hospital the same day. That's why we set the sentencing for today. So you're back today. I'm gonna get you to raise your right hand and we're gonna see what you want to offer. Do you solemnly swear or affirm the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth to help you God?
I do.
Thank you. And you've got some paperwork there with you?
Yes, sir. When you told me to go find the paperwork, I had my father look in his records when we got home, and I was hoping, my smile went to a frown. his release was on the 3rd.
And your ticket was on the 18th.
And he reminded me, he says the very next day, remember, he drove, but we both went up CVS and they put him on heart medicine that didn't jive with his insulin. So he was dizzy, and I may have drove up and got him a heating blanket at Walmart to help his lower back. But
Okay, so
it wasn't the same day, but he was.
it wasn't even the same week.
I know.
15 days later. So
Yeah.
tell me now.
And I apologize, sir.
Well,
ain't
I appreciate that, but what is your reason for driving on March 18th now, since you're now saying he did not get out of the hospital on that day?
Well, you can see my driving record. I haven't had a ticket since 2012.
14.
I'm scared to death to drive because of this.
So why did you drive on March 18th? I haven't heard a reason for that.
To help my father because he was still dizzy.
Okay. You haven't told me. You said you might have gone get a blanket at some point. You said you went to the pharmacy the next day after his release. So let's get your story
But
straight.
he drove.
March 3rd is when he got out of the hospital, right?
Yes, sir.
Okay. Why were you driving on March 18th? Because I haven't heard any reason whatsoever for that day. I need to know that.
Well, I'm just explaining that the pills made him dizzy, so he couldn't drive at that time. And I said, you're right.
So where were you going on March 18th?
I believe I was at...
This is where courtroom testimony becomes dangerous territory. The defendant isn't necessarily denying the original circumstances anymore, but the timeline is beginning to shift. What started as a same-day hospital release explanation has now evolved into a broader story involving medication side effects, dizziness, and helping a parent weeks later. The challenge is that judges pay close attention to consistency. Even honest mistakes can raise concerns when important details begin changing under questioning. Would you consider this a simple memory issue, or is the story becoming harder to believe?
I can't think, but Walmart to get him a heating blanket for his lower back because his lower back was killing him.
Okay.
He finally had to quit taking the heart pills because it didn't jive with his insulin, and he quit getting dizzy, and now he drives everywhere. But I'm just saying that was in the time of him in the hospital. I was mistaken on the exact day, but until we pulled out, because that was back in, a long time ago. For an old guy like me, I didn't remember it right. But yes, sir, I apologize to you and the court.
Thank you, Mr. Wilson. Mr. Mitchell, any questions for Mr. Wilson? First of all,
No, Your Honor.
Mr. McDaniel, any other testimony, evidence you want to offer, argument regarding sentencing?
No, I don't have any. If it has been, I'm not sure. I mean, you probably look at the record. If it has been since 2012, we just ask the court to take that into consideration. But, I understand what the court is going to do. So
I don't drive.
I understand, but you did drive. So, I mean, he's going
Yes, sir.
we'll see what happens.
2014 is what was said at the last hearing. And let's look at the driving record and see what the hearing has said. Mr. Mitchell told us that he got one in 14 and resolved it in 15.
Yeah, there was 14-8222CT in Marion County was the last thing I saw.
January 5th, 2015 was the last time he was in court. So, Mr. Mitchell, what's the state's position?
Sure, we made that original offer based on the prior DWLSRs that he had, but the last one was a dozen years ago or close to a dozen years ago, and then from 07 and 06. So we'll just leave it up to the court's discretion. We're
Okay. All right. Thank you.
not leaning one way or the other.
Here's the critical moment. The judge makes something very clear. He doesn't necessarily believe the defendant intentionally lied. In fact, he specifically refers to the date issue as potentially being an honest mistake. But the legal problem isn't just the mistake. It's that the justification for driving no longer meets the level of urgency originally presented. This is a great example of how credibility and legal justification are related but not identical. You can be honest and still lose your argument.
So, Mr. Wilson, had you had documentation that your father got out of the hospital that day, I was fully prepared to sentence you to probation. You don't have. Give me a vague reason for driving 2 weeks after you got out of the hospital, which is 15 days after, which is different than what you told me originally. I think the state's recommended disposition is appropriate. What their original recommended disposition is, I'm not going to punish you because I think it was an honest mistake, but it was in the dates. Driving was an honest mistake. You can't drive because his back hurts. You've got multiple DUIs. You can't drive. I'm sentencing you to 30 days in jail with credit for the time that you've served. Standard court costs and fines are $400. You very well may do less than that with Florida's game time laws. Does he have any credit, Mr. McDaniel? Was he ever arrested?
Joseph Wilson,
I think he was or never was arrested.
So you don't have any credit.
there's no credit. So
You have a separate charge of improper change of lane while being passed. Because you're getting a jail sentence, I'm prepared to waive the court costs and fines on that civil ticket if you want to resolve it today. If you want to go to a hearing on that, that's okay too.
No, I want to resolve it.
So show plea of no contest with improper lane change, waive the points, waive the fines, 30-day jail sentence imposed in the criminal case. Mr. Wilson, do you have any questions?
No, sir. Can I give my
Absolutely.
father?
Absolutely. Yes, sir. So he needs to be taken into custody to start that sentence. So, sir, he's going to do somewhere between 20 and 30 days.
25 and 30.
They can get up to 10 days a month, though, right?
Well, they can,
5 for the state and 5 from the county,
I guess they can, but they generally don't give them that extra 5.
because it takes too long to get in the program or
Yeah,
something.
because they can't get in the program fast enough. Sometimes they do, but generally speaking, it's not. They don't go to them. So generally.
So, sir, under the law, to his father, sir, legally, he has to do between 20 and 30 days. Mr. McDaniel's estimate is probably closer to 25 days, but that's between him and the jail.
Listen carefully to what the judge is saying here. He's drawing a distinction between a true emergency and a personal convenience. Courts often recognize that genuine emergencies may require people to act outside normal circumstances. But buying household items, even for a family member dealing with health issues, is generally viewed very differently under the law. This explanation gives us valuable insight into how judges evaluate necessity, reasonableness, and accountability when deciding sentences.
He could do a maximum of 30 if he gets in trouble at the jail, but there's no probation involved. He finishes this jail sentence, he's over with. And if it's a genuine emergency, he can drive. And I'll consider that. Let me back up. If it's a genuine emergency and he's charged in Jackson County and I have proof of the emergency, I'm going to consider that. But getting a heating pad is not a genuine emergency, in my opinion, if that's what he was doing. Okay. Wish you the best, Mr. Wilson.
He'll be out in about 4 weeks, okay? Good luck.
It's okay. We can give it to him later. Let's get him out of here now. So, Theo, hang on just a second. We'll give him his paperwork. Thank you, sir, for coming.
All right, that's about it. Yeah, I like how Judge Mercer corrected himself right there. It's like, it's not okay to drive, but if that's why you were driving, I'll consider it. And that's why he gives people the chance to get documentation that they're telling the truth. Again, we saw this about a month ago where a guy said, he was only driving because his grandmother was in the hospital and she had a heart attack. And then when he came back, she didn't have a heart attack and she was in the hospital. She wasn't in the hospital. Yeah.
Today's hearings highlighted one of the most important lessons in any courtroom. Credibility matters. In the first case, the court focused on compliance, procedure, and ensuring legal requirements were followed despite ongoing disputes. In the second case, the outcome turned largely on whether the defendant's explanation matched the evidence presented to the court. The judge carefully reviewed the facts, gave opportunities for clarification, and ultimately imposed a sentence based on the information available. Whether you agree with the rulings or not, these cases demonstrate how quickly legal outcomes can change when facts, timelines, and testimony are placed under scrutiny. Now we want to hear from you. Did the judges get these decisions right? Would you have ruled differently? If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.